judge's order. And the department's response to this gross miscarriage of justice was not to accept responsibility or to take urgent action to correct the problem and seek the man's return. No, the department's response was to punish the department's own lawyer for speaking truthfully to the court, for what it deemed an act of insubordination, for failure to give full-throated defense to the department's illegal act. This is why we are here today. We are here today because the rule of law and democracy in the United States is under attack, not by a foreign adversary or some distant threat. The rule of law is being attacked and subverted from within, from an administration intoxicated by its own power and enabled by a supine Congress. Donald Trump is taking unprecedented steps to bend our justice system to his will, and his administration is moving systematically and swiftly to dismantle the legal pillars that hold up our democracy: the independence of the legal system, the idea of impartial justice, the right to counsel, and the principle that no one, not even a president, is above the law. If Donald Trump and his personal criminal defense lawyers, now running the Justice Department, succeed, the consequences will be profound. The impact will be felt by Americans from all walks of life and by future generations. This is why Ranking Member Raskin and I have taken the extraordinary step of convening this unprecedented hearing. We brought together both chambers of Congress, the Senate and the House, to conduct real oversight and to serve as a check and balance, to hold those who misuse power to account and to carry out our constitutional duty. Convening this hearing was not our first choice. We have tried to get our Republican colleagues to hold hearings, to do meaningful oversight, to assert Congress's authority as an independent branch of government. But to our great disappointment, our Republican colleagues have abdicated that important responsibility. They have stood by as the President has run roughshod over the legislative branch and turned Congress into little more than a rubber stamp. So today we'll hold the first of what we hope will be more bicameral oversight hearings. We will do the investigative work that our colleagues across the aisle refuse to do. We will expose the illegality, abuse, and corruption of this administration and within the Department of Justice. We will have brave witnesses speak to what's actually happening behind closed doors, how the Trump administration continues to try to intimidate them from speaking out, and why it matters to Americans across the country. The Trump administration is following a well-worn playbook. History serves as a guide and as a warning. In the 1930s, a Jewish lawyer in Berlin tracked in meticulous detail how Germany gradually became what he called a dual state. First, to keep the country running, the ordinary legal system remained in place for most people. And yet, step by step, a parallel system of governance and law emerged, what one scholar called a lawless zone. A parallel system carry out the will of the leader and to go after his enemies, real or perceived, to punish, to reward, to co-opt, to intimidate, silence, or take over institutions that make a society free and vibrant: the courts, the lawyers, the universities, the press, even businesses. And over time, the emerging authoritarianism would swallow what remained of the rule of law. And now Hungary provides a more present-day warning. Methodically, Viktor Orban has tried to dismantle the independence of Hungary's judicial system, its education system, and free press, undermining democracy while pretending to uphold the law. And we have our own history that we must not forget. In the 1950s, in this very institution, Senator Joseph McCarthy and his enablers wielded the power of the government to go after perceived enemies. Many shamefully did not stand up at the time. Some chose expediency, political gain, or profit. Others thought they could weather the storm by cutting deals or staying silent. If this sounds all too eerily familiar, it is because it is. But there is a silver lining and a reason for hope. Those who defended fellow Americans then are now rightfully viewed as vindicated by history. The courage demonstrated by Americans in decades past and by brave men and women in other countries should serve as our inspiration and a roadmap for standing up for the rule of law, for each other, and for our democracy. Today's hearing, therefore, is a step towards real oversight and accountability. Our witnesses have demonstrated remarkable courage. like Ryan Croswell, who resigned after witnessing, as we all have, the corrupt use of the Department of Justice's prosecutorial power by striking an illicit bargain with the mayor of New York to do the administration's bidding. These witnesses refuse to enable a two-tier system of justice that grants favors and cuts corners for the famous or wealthy. And as we'll hear today, they bravely stood up to ongoing efforts by the Department of Justice to intimidate them from speaking today, including when they planned to send armed marshals to the home of one of our witnesses, Liz Oyer, in order to discourage her from testifying today. These witnesses, like Stacey Young, are supporting others who continue to serve the public interest, continue to be employed by the Department of Justice, and who cannot speak for themselves. One of our witnesses, Rachel Cohen, stood up when her law firm would not, even as other law firms beat a path to the White House to capitulate to the extortionary campaign of the executive branch, even as that campaign weakens the right to counsel, the right of free speech, and the right to take on unpopular causes. Today's witnesses represent the antidote to the collective action problem we have seen when law firms, universities, and other institutions race to the White House to cut their own deals rather than stand on principle. In this defining moment, our institutions must not grovel before power. They must not retreat. They must stand together. They must lead. Law firms, universities, public servants, Congress, each has a unique role, an important role to play, because a democracy that fails to hold power to account ceases to be a democracy at all, because we cannot allow the law to be twisted into a tool of personal or political vengeance or favor, and we cannot let threats to our democracy go unchallenged. Before we introduce the witnesses, let me turn to my colleagues, Ranking Member Raskin and Ranking Member Durbin, both of whom have demonstrated extraordinary leadership during this moment of profound challenge. I'm grateful that we are convening this hearing together, and I'm grateful for the courage of today's witnesses who have refused to remain silent. I now yield to my colleague, Mr. Raskin, for his opening statement, followed by Mr. Durbin.
Well, thank you, Senator Schiff, for those moving remarks, and thank you, Ranking Member Durbin. Thank you both for working with us to hold this oversight hearing, which Republicans on neither side of the Capitol were willing to call. Special thanks to our witnesses today. Your bravery is inspiring to an anxious nation today. Even in the face of great pressure, each of you has stood tall and held fast to your oath to uphold the Constitution and the integrity of the legal profession. Just as the president has crashed the stock market with his illegal tariffs, he has crashed the justice system with his dreadful appointments and vindictive policies. He's filled the leadership of the Department of Justice with his personal lawyers, unapologetically extremist sycophants like Kash Patel and Ed Martin, who elevate their devotion to Trump over any semblance of fidelity to the Constitution, the rule of law, and the rules of professional responsibility. Our witnesses are people who have refused to bow down and be complicit in the way so many of our colleagues have been complicit. The president fires dozens of DOJ lawyers simply for doing their jobs in prosecuting the January 6th insurrectionists who violently assaulted and wounded more than 140 of our police officers. The Republicans say nothing. The president issues executive orders banning disfavored lawyers and law firms from federal buildings, federal courthouses, federal employment, and federal security clearances unless they offer him blind loyalty and millions of dollars in free pro bono services for his pro-Malum causes. And the Republicans say nothing. Trump sacked 18 inspectors general who saved us $91 billion in actual waste, fraud, and abuse last year. His team gutted the Office of Public Integrity and suspended enforcement of the Foreign Corrupt Practices Act. They withdrew prosecution of New York City Mayor Adams on serious bribery and corruption charges because he formed an alliance with Trump, causing 7 top prosecutors to resign their offices, led by Danielle Sassoon, the U.S. Attorney for the Southern District, who clerked for Justice Scalia and was an active member of the Federalist Society. Our GOP colleagues are silent about these scandalous offenses. But House Republicans are outspoken about this. Many are calling for impeachment of the judges who've rendered 56 preliminary injunctions or temporary restraining orders against this reign of fear and terror. The president and Elon Musk go online and call them radical left rogue judges. Even Judge Boasberg, a pillar of the bar and chief judge of the D.C. District Court, who was first appointed to the bench by President Bush and was Justice Kavanaugh's roommate at Yale. We have only impeached 15 judges in the entire history of the United States, always for corruption offenses, bribery, tax evasion, habitual drunkenness, not even occasional drunkenness, habitual drunkenness, never for doctrinal disagreement with their rulings, much less when their rulings are manifestly correct. As Chief Justice Roberts put it a few weeks ago, the proper response to a decision you disagree with in the district court is to appeal the decision, not to impeach the judge. They're not making America great again, but they're definitely making the government corrupt again. We're grateful to you, witnesses, for having the courage to speak up against this outrageous corruption of our justice system as it came to affect you, and we're eager to hear your important stories. You will teach America how to stand tall. Ms. Oyer, I understand the Deputy Attorney General tried to send armed marshals to your home at night to deliver a clear message not to speak to us at today's hearing. And yet, I see you here today undaunted and unbowed, proving to Mr. Blanche and any other Trump official that you can't bully and silence everyone. That kind of courage is contagious, but we must emphasize to a watchful nation that courage is not the opposite of fear. Real courage, in fact, is experiencing all the fear, all the terror of these official threats and harassment, registering the fear of vigilante and online attacks, metabolizing the fear of your own government hounding you, but then pressing on anyway with conviction and passion for what you know to be right and lawful and just. No, courage, which is a virtue, is not the opposite of fear, which is an emotion, and indeed a necessary and adaptive emotion. Courage is a virtue, and it's the opposite of cowardice, which is a vice. The worst cowards are the tyrants and despots themselves who choose to terrify other people because they have allowed their own terrible fears and insecurities to turn them into monstrous, deformed, and cruel people. But the people who enable tyrants and despots, who do their bidding and work their will and flatter them and bow and scrape before them, they are cowards too, undoubtedly, at least if they have any choice in the matter. Every authoritarian regime runs on lies and runs on fear. Every authoritarian regime fears the truth and fears people who act justly and defiantly based on the truth. And that means they fear people like you and what you have to say to your fellow citizens. Thank you for recognizing the fear of this moment, feeling it, and nonetheless deciding to go ahead and act with courage and composure against the tyrant and his accomplices. I yield back to my very good friend, Senator Schiff, and I turn it over to Mr. Durbin for his opening statement.
Thank you very much, Congressman Raskin. It's an honor to be here. All across America this last weekend, thousands of people, many whom never participated in a political event, came out to demonstrate their concern about the current state of the American government and what is happening with this administration. There were 1,000 in Springfield, Illinois, some 50,000 in Chicago, Illinois, and that story is repeated over and over again. We are at a unique moment in our history. Presidents have constitutional issues, virtually all do, but few have a constitutional crisis, which we are facing now in this country. I want to thank Congressman Raskin for coming here today, along with his colleagues from the House, and thank my colleagues from the Senate. But I want to particularly thank Senator Schiff. He's in a unique position, bridging the experience you had in the House of Representatives with this administration, and now your responsibility here in the United States Senate. I think this may be unique in American history, but it's certainly warranted, and I thank you for your leadership, Senator, in bringing us together. When you take a look at what we face today, it is truly a constitutional crisis. How did it start? Well, it certainly started with questioning a legitimate election and the outcome. Stop the Steal movement was an indication of pure effort to stop the Constitution from working its way. But the courts rejected President Trump's efforts to turn the results of the election, and now we see what he does in his second term. First, President Trump has gutted and weaponized the Department of Justice and our federal law enforcement agencies. The Justice Department is supposed to enforce our laws and protect our citizens, but President Trump appointed his personal attorneys to fill numerous senior positions at DOJ, including Attorney General and Deputy Attorney General. As many of us predicted, the new DOJ leadership has treated the Justice Department like the president's personal law firm. From dismissing corruption charges against Mayor of New York in exchange for supporting the president's policies, to restoring gun rights to domestic abusers who supported the president, to threatening universities that don't toe the MAGA line, the Justice Department has abandoned its commitment to the rule of law to advance the personal and political interests of Donald Trump alone. We need to fight back against this weaponized Justice Department. That's why I led the Judiciary Democrats in filing a bar complaint against Trump DOJ official Amo Bove for his role in corrupt bargaining with Mayor Adams. That's why I've led the Senate Judiciary Democrats in demanding an explanation from Attorney General Bondi for the firing of the pardon attorney and the restoration, for God's sakes, of Mel Gibson's gun rights. This brings me to the second way in which President Trump has threatened the rule of law, targeting law firms simply because they dared to employ attorneys who were involved in litigation or representations that the president didn't care for. We have long recognized the importance of parties before a court having representation by attorneys of their choosing, even in unpopular and politically charged cases. This goes back to the founding of the Republic. John Adams, our second president and one of the nation's founding fathers, famously represented 9 British soldiers accused of perpetrating the Boston Massacre. The right to counsel is so fundamental that it's enshrined in the Sixth Amendment. But instead of protecting and defending the Constitution, as he swore to do, President Trump has used his position to settle political scores and target law firms he deems insufficiently loyal. Over the past 2 months, he's issued executive orders and attempted to suspend security clearances, limit access to government buildings, and prohibit government contracts for certain firms. If those orders sound lawless, it's because they are. And multiple federal courts have appropriately blocked large portions of those executive orders. The Republicans on the floor and in the committee complain and moan and groan about all of the judicial cases that have been ruling against them, and many have. The fact of the matter is that this president has issued over 100 executive orders, many of which fly directly in the face of clear constitutional law. The president's actions pose an existential threat to the targeted law firms. Some have capitulated. For other firms, even the threat of future executive orders was enough to lead them to preemptively cut deals with the Trump administration. That, of course, is the point. The president wants to intimidate law firms so they'll think twice before taking on a client whose rights have been violated by the administration. That should alarm everyone. This is the kind of thing we expect from tin-pot dictatorships in other parts of the world. But these kinds of attacks on lawyers and the rule of law are unprecedented in the United States of America. They are not normal, and we cannot allow them to continue. I look forward to hearing from the witnesses, and thank you for your courage coming forward today. It's important that we hear this story that each of you has lived. And I want to close by saying to all those who gathered across America and who communicate through social media, asking what Congress is doing to try to stop these excesses and these violations of the Constitution, remember what happens on this day. Because on this day, I think we are making history at the right moment. Thank you, Senator.
Thank you, Ranking Member Durbin. We'll now introduce the witnesses, and these will be the briefest of introductions so we can leave more time for testimony and questions. But today we're joined by Liz Oyer, who previously served as the pardon attorney at the Department of Justice. We're also joined by Stacey Young, who previously served as an attorney in the Civil Rights Division in the Department of Justice. We're also joined by Ryan Croswell, who served as a federal prosecutor in the Public Integrity Section of the Department of Justice, and Rachel Cohen, who served as an associate attorney at Skadden, one of the largest law firms in the world. Thank you for being here, and we'll turn it over to you for opening statements. Ms. Ware, why don't you start us off?
Thank you very much. Exactly 1 month ago today,
Can you turn your mic on or bring it close?
can you hear me now?
A little closer, if you would.
How's that?
Better, thank you.
Right. Thank you for having me. Exactly 1 month ago, I was terminated from my job as the Justice Department's pardon attorney. The pardon attorney is a non-political position that is entrusted with advising the president about the exercise of his constitutional clemency power. When I was fired, there were over 6,000 applications pending from ordinary Americans around the country who were seeking the president's mercy and second chances through clemency. I had planned to talk today about the events leading up to my firing, but some more recent developments have persuaded me to focus my time on the callous cruelty with which DOJ leadership is treating dedicated public servants like myself. For me, this began with my abrupt firing. It was 2:00 on a Friday afternoon. I was in a conference room meeting with colleagues from several different DOJ offices. We were brainstorming about how to implement a priority of the Attorney General. Halfway through the meeting, I was frantically pulled out by my deputy. In the hallway, she broke the news to me that security officers were waiting for me in my office to serve me with termination papers and escort me out of the building. I rushed back to my office. There, I was handed a 3-sentence memo signed by Deputy Attorney General Todd Blanche, firing me effective immediately. I had never met Mr. Blanche, and I received no explanation for his decision. That afternoon, I walked out of the building for the last time carrying a grocery bag filled with my personal effects. I had no time to say goodbye to my team. I was in shock. Everyone I passed on the way out was looking on in shock and horror. I want Deputy Attorney General Blanche and Attorney General Bondi to know it is traumatic for everyone in an entire organization to see a beloved colleague and leader treated that way. My heart aches for my colleagues who had to go back into that office on Monday with no explanation from DOJ leadership and no assurances about what the future holds for them. They are good, dedicated people, and they deserve better. After I was fired, I chose to speak publicly about the events leading up to my termination. I felt that it was my obligation to share my concerns about the reckless and unethical use of department resources to accomplish political objectives, including favors for loyalists and friends. Shortly after I did so, Mr. Blanche contacted the media to accuse me of lying. This still puzzles me because his staff has all of the memos and emails that substantiate everything I have ever said. I requested those documents through FOIA, but Mr. Blanche's staff still has not produced them. I have made some other simple requests of the department since my firing. One was for my annual performance evaluations, which show that I received outstanding ratings every year. One was for personnel documents that I would need to file for unemployment. DOJ responded to me that these were complex requests and I could not expect a response in any reasonable period of time. For weeks after my firing, DOJ also refused to provide me with documents about my benefits, including my health insurance and including my retirement plan. Finally, on April 2nd, after my requests got some media attention, I got an email advising me that my health insurance would expire in 5 days. I learned that to extend my coverage, the cost to me and my family would more than quadruple. I was told that to keep my family members covered, I would have to prove my familial relationships with them. I was told that I would need to provide my marriage certificate, the birth certificate of my child, and proof of a common residence or joint tax filings with my spouse. Perhaps the most personally upsetting part of the story is the lengths to which the leadership of the department has gone to prevent me from testifying here today. On Friday night, around 9:15, I learned that the Deputy Attorney General's office had directed the Department's Security and Emergency Planning Service to send 2 armed Special Deputy U.S. Marshals to my home to serve me with a letter. The letter was to be served at my home between 9 o'clock and 10 o'clock on Friday night. I was in the car with my husband and my parents, who are sitting behind me today, when I got the news that the officers were on their way to my house where my teenage child was home alone. Fortunately, due to the grace of a very decent person who understood how upsetting this would be to my family, I was able to confirm receipt of the letter to an email address, and the deputies were called off. The letter had been emailed to me just before 8 o'clock that night. At no point did Mr. Blanche's staff pick up the phone and call me before they sent armed deputies to my home. The letter was a warning to me about the risks of testifying here today. But I am here because I will not be bullied into concealing the ongoing corruption and abuse of power at the Department of Justice. DOJ is entrusted with keeping us safe, upholding the rule of law, and protecting our civil rights. It is not a personal favor bank for the president. Its career employees are not the president's personal debt collectors. I see only Democratic members here today, but this is not a partisan issue. It should alarm all Americans that the leadership of the Department of Justice appears to value political loyalty above the fair and responsible administration of justice. It should offend all Americans that our leaders are treating public servants with a lack of basic decency and humanity. Thank you.
Thank you for your testimony and for the courage you're demonstrating by being here. Jamie, did you want to introduce Mr. Croswell?
It's my pleasure to introduce Mr. Ryan Croswell, who previously served as a federal prosecutor in the Public Integrity section of the Department of Justice, and Rachel Cohen, who previously served as an associate attorney at Skadden, one of the largest law firms in the world. We thank you both for being here. And now, Mr. Croswell, you're recognized for your 5 minutes.
Good afternoon. Ranking Member Raskin, Ranking Member Durbin, Senator Schiff, and members of the House and Senate Judiciary Committees. For 10 years, I served as a federal prosecutor with the Department of Justice, but I started my career in public service as an officer in the United States Marine Corps. I was motivated to join the military after September 11, 2001, and I've tried to live my life by the Marine Corps ethos: honor, courage, and commitment. My career as a federal prosecutor started in Baton Rouge, Louisiana, where I prosecuted white-collar fraudsters, drug traffickers, child predators, and violent criminals. I then served as a prosecutor in San Diego, California, where I prosecuted border crimes, including immigration offenses and the smuggling of dangerous drugs into this country from Mexico. Finally, for the last 4.5 years, I served as a prosecutor with the Department's Public Integrity Section. The Public Integrity Section was formed in the aftermath of Watergate, and it prosecutes corruption at the federal, state, and local levels. Throughout my time with the Justice Department, I followed the principles that guide all federal prosecutors. Follow the facts and the law wherever they may lead. Seek justice in an even-handed and apolitical manner. Act with fairness, impartiality, integrity, and adherence to the rule of law. On February 17th of this year, I resigned from the department as part of a sequence of events that can only be described as among the saddest in the department's history. I want to make clear that I had no role in the prosecution of New York City Mayor Eric Adams. My knowledge as to the facts and the evidence are limited to that which has been publicly reported. Let me also state that I speak for myself and myself alone. The chain of events that led to my resignation began when the acting Deputy Attorney General ordered the United States Attorney's Office in New York to dismiss the case against Mayor Adams. This was not based on the prosecution's merits. And we know this because he openly acknowledged in a memorandum that department leadership had decided to dismiss the case, quote, without assessing the strength of the evidence or the legal theories on which the case is based. This action leveraged the threat of future prosecution to ensure political compliance. The message that this sent, intentionally or unintentionally, was that public officials may be prosecuted or may be protected from prosecution as long as they're politically aligned with the Trump administration. In a properly functioning justice system, any public official wishing to avoid prison has to live by one rule of thumb: obey our nation's laws. And this action raised an even more chilling question. Is the Justice Department that will drop charges against those who acquiesce to a political demand a Justice Department that will bring charges against those who don't? When the acting U.S. Attorney in the Southern District of New York stood up for the rule of law and resigned rather than carrying out the order, the case was transferred to the Public Integrity Section. When our acting chief and our deputy chiefs stood up for the rule of law and resigned rather than carrying out the order, the remaining attorneys in our section were ordered to find 2 attorneys to sign a motion to dismiss. Ultimately, one of our attorneys signed a motion to stop the destruction of the section. The Public Integrity Section has protected the American people against abuses of power for nearly 50 years. But it was nearly eliminated in an hour over a dismissal of charges against a man that a grand jury had found to have engaged in a criminal abuse of power himself. At this point, too many lines had been crossed, and so I too resigned. The threats against current members of the legal community, both in public service and private practice, are real and they're of consequence. To those attorneys facing such threats, I share with you a message that I received on the day that my colleagues and I were ordered to dismiss the Adams case. It came from a fellow Marine. It read, "Keep your head up and keep your values and your oath at the forefront." Every attorney who takes an oath to uphold the law and every citizen who values democracy must have a line in the sand that cannot be crossed. Speaking out and doing the right thing increasingly comes with personal risk. But the day after I resigned, my sister had her first daughter, and I want my niece to know the same democracy that I've known. That's worth any cost. That's worth fighting for. Thank you.
Thank you very much, Mr. Crosswell. Ms. Cohen, your opening statement, and I should take a second of personal privilege over here in the Senate just to say that Ms. Cohen was very close friends with my son Tommy at Harvard Law School, and he always told me that you were a woman of great intelligence and great character. It's good to see you.
Thank you. I'm grateful for the opportunity to speak to the members today. I acknowledge this is not the first Monday of unemployment that I anticipated, but I am appreciative to be here. On March 20th, I tendered my conditional resignation to Skadden Arps, where I was employed as a finance associate. I did so because I believe our country is teetering on the brink of authoritarianism, and that many leaders of our most prestigious and profitable law firms recognize this risk and choose to ignore it because they are afraid. It's likely they're afraid of losing profits, but I think it's also likely that these leaders are afraid because standing up to authoritarianism is scary. It is easier to ignore what is happening than to acknowledge the fight that lies ahead. I resigned amidst a series of attacks on the legal profession that began on February 25th when the Trump administration stripped large law firm Covington and Burling of government contracts for representing special counsel Jack Smith during his investigation of the president. Then, the president entered an executive order against law firm Perkins Coie, not only stripping Perkins of government contracts, but also targeting third-party contractors that retain Perkins as counsel. Again, the administration named Perkins as past representation of clients and causes the president dislikes as the cause. Perkins chose to fight back. It challenged this blatantly unconstitutional order and successfully won a temporary restraining order the next day. In a normal presidency, this sends a message to the administration: press pause while the Perkins executive order is litigated. But the president continued to enter executive orders targeting firms based on past representation. Enter Paul Weiss, the next target of an executive order. Instead of fighting back, Paul Weiss offered the Trump administration $40 million in pro bono legal services for pet projects and promised to evaluate hiring and retention practices in partnership with the president. He withdrew the order. Paul Weiss's decision was a stunning betrayal of the firm's associates and the legal system that made its partnership very, very rich. Like calling this hearing, resignation was not my first choice. Throughout this period, associates across the industry were engaged in measured advocacy internally and externally, hoping to get our firms to band together and stand up to the administration's attacks on the broader legal profession. Paul Weiss's capitulation made me realize firm leadership was not motivated to act collectively. I became certain my employer was not going to be brave, and so I resigned. I was heartbroken to be proven right 8 days later on March 28th, when Skadden promised the Trump administration $100 million in pro bono legal services despite no executive order being entered against them. Other associates resigned in protest, 2 of them publicly. They're sitting behind me, and I am so unbelievably grateful. We did so because our adversarial legal system only functions when parties have representation. Everyone deserves an advocate. That principle is invoked by law firm partners to justify high profit but distasteful representations. Everyone deserves an advocate. American justice is not sua sponte. Without skilled lawyers, meritorious lawsuits may never be brought in the first place. Public interest attorneys, themselves separately targeted by the administration, are now also scrambling to replace resources and attention these firms historically provide as they challenge unconstitutional actions and provide direct representation to clients in need. This is intentional. Courts are perhaps our last line of defense against authoritarianism. I was raised to advocate and to be aware of the racial, financial, and other privileges I hold that make it more likely that my voice will be heard in halls of power. I am the daughter of 2 government attorneys who both served their country in the United States Air Force. While in high school in Ohio, my best friend was one of the only Latina students in our graduating class and faced overt racism. And I remember following a particularly egregious incident when we went to the principal together, how my outrage was heard as much or more than hers. After studying political science at The Ohio State University, I spent 4 years teaching in Providence Public Schools, and my students, some of whom I know are watching right now, are brave and smart and bold, but there were many times where, despite the self-evidence of my students' brilliance, people did not believe it existed until a white native English speaker pointed it out. Acceptance to Harvard Law School and employment at Skadden made my already powerful voice even louder. The cowardice or apathy in some of these spaces at times caused disillusionment, but those dear to me, including your son, Congressman Raskin, made sure I remembered that just because such cowardice is common doesn't make it acceptable. And as you said, courage is a choice. I was asked here because my voice is loud, but I came here for the same reason I resigned. It is important for the very real people whose voices are not heard in the same way to have an advocate today and always. This advocacy cannot be defined by fear of future retribution. My students and non-white friends and colleagues deserve brave advocates. Mahmoud Khalil, Rumaiza Ozturk, Kilmar Armando Abrego Garcia, and Andre Jose Hernandez Romero deserve brave advocates. People seeking abortion care or birth control or gender-affirming care deserve brave advocates. And to be clear, everyone else, the law firm partners enabling this slide into autocracy, the voters who put Trump into office and are waiting and will wait forever for him to care about the difficulties that they face. Those of us in this room today, we all deserve brave advocates. The administration cannot pick and choose who gets representation. It cannot use executive power to scare lawyers out of advocacy. If we allow any president to dictate who deserves a lawyer, our legal system fails. Like firm leaders, I am afraid of where this intimidation campaign leads. But unlike most of them, I will not allow my fear to manifest as silence. I choose courage. Thank you.
Thank you for your testimony, and I hope your courage and that of your two colleagues seated behind you will be contagious among the bar. Ms. Young, thank you for your service in the Civil Rights Division, and you're recognized for your testimony.
Thank you. Ranking Member Raskin, Ranking Member Durbin, Senator Schiff, and members of the committees, thank you for the opportunity to appear at this important hearing about the ongoing attacks on the Justice Department. After 18 years as a career litigator in DOJ's civil rights and civil divisions, I recently founded Justice Connection, an organization mobilizing DOJ alumni to support the department's workforce. The Justice Department's 115,000 employees come to work every day to uphold the rule of law, keep our country safe, and protect our civil rights. All but a few hundred of these employees are career civil servants. The department's employees shield our communities from gun violence, prevent terrorist attacks on American soil, investigate and prosecute drug traffickers responsible for the deadly fentanyl epidemic, and so much more. Yet the Trump administration has unleashed an all-out assault on these public servants who are now facing attacks on their employment, their integrity, their well-being, and even their safety. Over the past 3 months, employees at all levels have been fired, suspended, demoted, and reassigned. They include senior career officials across the department, including in law enforcement components like the FBI and ATF. They also include officials assigned to cases disfavored by this administration. Many have been forced to resign rather than follow orders they concluded were unethical or unlawful. The attacks on the department's workforce are too widespread and numerous to catalog in a single hearing. But I'd like to highlight 3 particular aspects that are especially alarming. First, the administration's purge of career law enforcement and national security employees makes us less safe. Congress should be deeply concerned about the termination of some of the most senior leaders at the FBI and the ouster of top officials from the department's National Security Division, Criminal Division, and ATF. Removing these investigators and prosecutors has left our communities more vulnerable to violent crime and terrorism. Proposals to restructure and downsize the department's law enforcement work, for example, by merging ATF and DEA, will only make the problem worse. Second, the department's political leadership is getting rid of career employees because they refuse to behave unethically. To be clear, career employees should carry out the policy priorities of the executive branch, even when those priorities change across administrations. That's why long-term career lawyers like Erez Ravani zealously represent the interests of the United States in controversial cases, regardless of underlying policy judgments. But department officials must still follow ethical requirements, court rules, governing statutes, and the Justice Manual. Increasingly, career employees are being told that to keep their jobs, they must ignore their ethical duties and oath to uphold the Constitution. We should all be grateful to Erez Ravani and others who choose the rule of law over partisan loyalty, a choice DOJ employees should never be forced to make. Finally, the interim U.S. Attorney in the District of Columbia has run roughshod over prosecutorial norms, threatened investigations of dedicated career prosecutors, and carried himself as a general in the president's war on his enemies instead of a backstop on crime in our nation's capital. Ed Martin Jr. came to the job with no prosecutorial experience and a history of representing January 6th defendants who his new office spent years successfully prosecuting. He's destabilized his office by firing prosecutors involved in those cases and demoting widely respected supervisors, in the process cratering morale and unit cohesion and eroding the judgment, experience, and institutional knowledge that are essential to the office's vital work. If his reign continues, DC will be far more vulnerable to drug trafficking, terrorist attacks, and violent crime. The animus facing DOJ employees is unlike anything I saw in my nearly 2 decades of service, and I don't believe there's any precedent for it in the department's history. We can't expect employees to counter these attacks alone. Protecting them and DOJ's mission-critical work must be a top priority of every member of your committees and of all Americans who will suffer if the department is destroyed. Thank you.
Mr. Raskin, you want to begin questions?
Thank you very much. Ms. Oyer, the DOJ tried to stop you from coming today because they were very eager to silence your voice. You were fired hours after you refused to agree to the Deputy Attorney General's demand that you sign your name to a memo and that you recommend that Mel Gibson, a convicted domestic abuser who also happens to be a friend of Donald Trump and his special ambassador to Hollywood, get all of his gun rights restored. Is that right?
That's right.
And you refused to be complicit in that sequence of events because you had serious concerns. You said, quote, he is the profile of exactly who you would not recommend for this type of relief, citing his history of domestic violent abuse, alcohol abuse, and so on. Is that right?
That is correct.
And you were fired just a few hours after you told the Deputy Attorney General that you could not go along with this request.
Within hours, yes.
Now they're disputing your account. They're calling you a liar. You filed a FOIA request to demonstrate exactly what happened. Have you gotten the documents back yet?
I have not gotten any of the communications between myself and members of Mr. Blanche's staff, which illustrate that everything I have ever said about this matter is true.
And we have some of your contemporaneous communications with your own colleagues that corroborate your account.
That's right. I did, pursuant to FOIA, get some documents that were in possession of the Office of the Pardon Attorney, and they also corroborate my account.
All right. Then they had sent 2 armed marshals to your home to try to intimidate you with a letter telling you not to come today. Why did you decide to come?
I came because I don't want to be complicit in what is happening inside the Department of Justice, which is the misuse of the resources of the department to do political favors for friends of the president, for loyalists, and I just don't believe that that's right, and I don't want to be part of it, so I feel that I need to speak up.
Your courage is heroic to us, and I want to say to you and your family, thank you, and we are with you, and we're going to stand by you. Just this past weekend, we saw another shocking example of retaliation. DOJ suspended the prosecutor who had stated in court that a man, Kilmar Abrego Garcia of Maryland, had been erroneously deported to El Salvador as an administrative error and imprisoned there, where he faces serious danger and gang violence. The judge in the case demanded that the Trump administration seek Garcia's return to the United States, and the administration is, despite confession of its error, arguing to prevent Mr. Garcia's return, saying he's out of the custody of the United States, and they wash the hands of the matter. Ms. Young, is there any doubt in your mind that this prosecutor's suspension was retaliation simply for speaking the truth in court, as this prosecutor was sworn to do?
That's what the facts seem to suggest.
Well, I think that all of these events should stir the conscience of America, and we thank you all for stepping forward now to sound a cry about what's taking place. I yield back to you, Mr. Chairman.
Thank you, Mr. Raskin. I just want to put a fine point, Ms. Oyer, on your testimony. You applied the same standard, did you not, with reference to Mel Gibson, you would apply to anyone. That is, you looked at the facts to determine whether you should recommend restoration of gun rights. You didn't consider friendship with the president or any other impermissible consideration. You just looked at the facts. Is that right?
Well, Mr. Schiff, let me say that this is a project that was not within the normal purview of the Office of the Pardon Attorney. There was no real interest from this administration in considering the work that this office normally does, which is provide advice that is non-political in nature to the president about how to use his constitutional clemency power. So this whole project was something that was very different. It was not the normal work of the Office of the Pardon Attorney, but we jumped in and tried to do our best to support it because we understood that it was a priority of the leadership of the department. And in doing so, a primary concern was considerations of public safety. Would we be able to recommend that someone could safely receive their firearm rights back? And that was my concern in the case that you have discussed, that I did not have enough evidence in front of me to make the recommendation that that could be done safely.
So based on the evidence in front of you, you didn't believe it could be, the restoration of gun rights to Mel Gibson could be done safely?
I did not have enough information to convince me that I could recommend that it could be done safely.
And, you know, your description of the Office of the Pardon Attorney raises another question, which is, was your office consulted on the, 1,550 pardons of the January 6th insurrectionists that were granted by the president?
I learned about those pardons on the news just like every other American.
And were you the head of that office?
I was.
I remember Pam Bondi testifying, I think in this very room, that she was going to go through those cases one by one. Normally, a pardon request for any of those individuals would have gone to your office for review and examination to determine if there was a grounds or there was acceptance of responsibility or service of time or whatnot. Would that have been the process?
The ordinary process is that individuals apply through the Office of the Pardon Attorney. The office carefully vets the applications that we receive, and we look at all of the individualized factors that would support or weigh against a pardon in a particular case, and we make a recommendation on that basis. That's not something we were asked to do in that context, and in fact, it's not something that the office, as of the time of my departure, had been asked to do at all in the context of clemency grants by this administration.
So in the case of Mel Gibson, there was one standard for a friend of the president for a Hollywood celebrity with respect to gun right restoration, regardless of the public safety issue. In the case you testified about, Mr. Croswell, you resigned after your office, attorneys in your office, were asked to dismiss a case against the mayor of New York, which a grand jury found probable cause to believe he had engaged in corrupt acts. Your attorneys were asked, your colleagues were asked to dismiss that case, not because of any flaw in the evidence, not because of any insufficiency in the evidence, but because of some kind of a bargain between the Department of Justice and the mayor regarding an unrelated policy matter, that is immigration. Is that your understanding from the public record?
Senator, the memo that the acting Deputy Attorney General sent to the U.S. Attorney's Office in New York explicitly stated that it wasn't based on the facts or the legal theories on which the case was based. So that was very explicit.
And I was an assistant U.S. attorney for almost 6 years in California, and I just want to underscore how truly extraordinary that is, what you just testified, that a meritorious case is dismissed against a politician, not because of a flaw in the evidence, not because of any prosecutorial misconduct, but because of an interest in having that politician carry the president's water over unrelated policy matters. I never saw anything like that in my almost 6 years in the department. Have you ever seen anything like that in your experience?
Senator, in really from when you start as a federal prosecutor, you're trained that everything is based on the facts and the law. We prosecute based on the facts and the law, and that ensures that we're holding the bad guys accountable, and innocent Americans remain free. As long as it's based on the facts and law, that's the best way for us to be doing our job effectively to keep the American people safe.
And I just want to underscore before I turn to Ranking Member Durbin something you said in your testimony too, which is if the Justice Department believes that it can intervene in the case of friends of the president like Mel Gibson to give him special treatment, or in the case of the mayor of New York to give him special treatment because of unrelated policy help to the president, they can also weaponize that same Justice Department against the president's perceived enemies. And Senator Whitehouse has well demonstrated how that principle has applied in going after funds made available for renewable energy projects under the Inflation Reduction Act. Thank you for your testimony, and I now yield to Senator Durbin, Ranking Member Durbin, for his questions.
Thank you, Senator Schiff. And let me say to all of the witnesses who are here today, this remarkable hearing should help to restore the nation's faith in the democracy and the courage of the witnesses who have come here today to testify, and the courage of their family who stand behind them. Ms. Hoyer, it's my understanding that there are guidelines to be considered with pardon petitions. And among those guidelines, there's a requirement that they be granted in part based on, quote, the petitioner's demonstrated good conduct for a substantial period of time after conviction and service of sentence, and that, quote, a petitioner should be genuinely desirous of forgiveness rather than vindication. One of the first acts of office, obviously, of President Trump was the full unconditional pardon of 1,600, the number I'm not sure of, but I think it's in that range, of those who participated in the insurrectionist riot here in the Capitol. Most of us at this table were witnesses to those crimes and certainly understood what happened to the men and women in law enforcement who still protect us to this day and risk their lives for us on January 6th. I've taken a look at some of those who were given these pardons and gone through what they have done even since, in the few weeks since that happened. It is outrageous, some of the conduct that has been well documented. My question to you as a pardon attorney at the time, were you consulted on the pardons of the January 6 rioters?
I was not consulted. No member of my office was consulted about those pardons.
What would have happened to the pardon request for January 6 offenders had the normal DOJ pardon process been followed?
Had any of those individuals applied for a pardon, they would have been in due course fully vetted on an individualized basis, and the office would have formed a recommendation about the individual applicants, which would have been provided to the president. The whole role of the office is to ensure that some uniform and consistent standards are provided, and more importantly, the role is to ensure that people who are waiting their turn, who have meritorious cases, that those cases can make their way to the president's desk. Those folks who have access to the White House through the front door, they don't need the help of the Office of the Pardon Attorney to elevate their cause. And there are thousands of ordinary Americans who are seeking the mercy of the president through the clemency process, who are not being considered right now because the office is not being consulted. There are individuals who are serving incredibly lengthy sentences under outdated mandatory minimum sentencing laws who are seeking reductions of their sentence, people who have demonstrated rehabilitation over the course of decades in prison. There are people whose family members are writing in pleading for their return home. There are individuals who are in the community doing incredibly well, who have demonstrated rehabilitation and given back over the course of years, who are asking for pardons. And all of those people are on hold because No interaction was happening as of the time of my departure between the Office of the Pardon Attorney and the White House about clemency. The only people being considered for clemency were people who had some sort of inside access, inside track to the White House and could get their cases in front of the president without going through the ordinary process. And that is very concerning, and it causes real reason to lose confidence in the clemency process and real damage to our system of justice.
Have you followed what has happened to those who were given pardons by President Trump who were engaged in assaulting law enforcement here on Capitol Hill? Have you followed any of the cases, what has happened to them since?
I have, sir.
And what have you seen?
Well, there seems to be chaos in litigation that's happening around the country about determining what the intended scope of the pardons was. That's one thing I've observed, and that's one way that you can tell that my office was not involved. Had we been involved, we would have written the paperwork in an intelligible, clear way so there was no ambiguity about what it meant. But instead, there is litigation happening around the country in which the department is taking inconsistent positions and reversing itself about what those pardons mean. They have created a lot of chaos in a lot of different ways, and that is not the way the process is intended to work.
At least one of these people has been shot dead assaulting a police officer. Are you aware of that?
I don't want to overstep the area of my knowledge. I've seen things in the news, but I don't have any personal knowledge about the facts of that case or others.
Mr. Chairman, let me conclude by saying that last week our New Jersey colleague showed strength and resolve and courage to stand for more than 25 hours to speak for fairness and justice. He made history. This hearing continues in that spirit. Thank you all for your courage in attending.
I'd like to recognize Mr. Nadler from New York for his questioning.
Thank you, Mr. Chairman, and thank you for holding this important hearing, shining a light on the most lawless administration in history. Donald Trump may pride himself on mastering the art of the deal. What he has really perfected is the art of the shakedown. Look no further than the corrupt quid pro quo with the mayor of my own city of New York, Eric Adams. After cozying up to Donald Trump, the charges against him were dismissed without prejudice. Was it because the prosecutors determined there wasn't sufficient evidence to bring him to trial? No, it was because Donald Trump wanted something from him. He wanted the mayor to help carry out his extreme immigration agenda against the wishes and the well-being of millions of New Yorkers. So he and his administration orchestrated a corrupt bargain to drop the charges in exchange for the mayor doing his dirty work, and by dismissing the charges without prejudice, meaning they could be reinstated at any time, effectively kept the mayor on the hook to assure he did whatever Trump wanted. And of course, there is the president's effort to bully and intimidate major law firms that employ lawyers who dared to try to hold him accountable when they served in government. His campaign of retribution is a classic case of extortion, threatening the livelihood of these firms unless they do his bidding. If it weren't for the Supreme Court's immunity ruling last year, Trump could be prosecuted for extortion, violation of the Hobbs Act. Of course, Trump's captive DOJ would not prosecute in any event. Mr. Crosswell, thank you for being here. In your testimony, you told us about the reasons why you resigned. Perhaps you can elaborate. I know you did not work directly on the case, but how would you characterize the evidence you have seen publicly reported against Mayor Adams? Was it substantial? Was it overwhelming? What were some of the most egregious examples of public corruption you saw in this matter, particularly as it related to the mayor?
Thank you for the question, Congressman. You know, the case had not been dismissed with prejudice by Judge Ho last week. Mayor Adams would have had his trial, and like any other citizen, he'd be presumed innocent until proven guilty. That said, it was obviously deeply concerning that this was being dismissed for reasons that had nothing to do with the evidence. And so in terms of my own resignation, that was concerning. I probably would still be a public integrity had it not been for the fact that then five of my colleagues, incredibly talented, dedicated, and friends of mine with deep integrity then also had to resign because they wouldn't sign the order. And that really kind of goes back to my experience as a Marine officer. You take care of the people that work for you and you expect them to do the right thing. You don't force them to resign over it.
But based on public reports, you don't want to characterize the strength of the evidence at this point in that case?
Sorry.
I said, based on public reports, you don't want to characterize the strength of the evidence in the case?
If Congressman, if everything that was alleged in the indictment would have been able to be proven by the prosecutors, that looked like it would be a strong case.
Thank you, Mr. Croswell. Ms. Cohen, thank you for being here and sharing your story with us. I know you mentioned why you left Skadden Arps in your testimony. Can you tell us more about why you think the law firm gave in to the president's demands, how intense the pressure is coming from the administration, and how dangerous that type of pressure is to the rule of law in this country?
Absolutely, thank you. I think that the strength of the pressure is exponentially higher because law firms are not standing together and are instead treating the president's attacks as if they are normal course and not something that would easily be challenged in a court. And so I think that the pressure here comes from presuming that standing up to the president means you fall out of his favor. I think that ultimately, because these executive orders have pointed to past representation, particularly challenging the government, it's massively dissuading large corporate law firms from taking cases that might be viewed as problematic to the Trump administration. They were instrumental in 2016 in bringing challenges against unconstitutional action, but it's not limited to 2016. Large corporate law firms provide a significant amount of financial and staffing resources to public interest organizations that are challenging unconstitutional actions under both Democratic and Republican presidents. They also provide an immense amount of direct services work, like to migrants seeking asylum and to veterans seeking benefits, things that the president alleges may be frivolous or counter to his interests.
Thank you. And if lawyers are too intimidated to take on the administration when it clearly violates the law, then what remedy do any of us have to enforce the law and protect our rights from a president with dictatorial demands?
Given the nature of our adversarial system, we have almost no hope. That's why we have to act now.
And
Thank you. I think we've got to shift back to the Senate side now because we're impinging on their time. So.
Thank you, Mr. Nadler. And I regret to announce that the Chief Justice, during the course of the hearing, Chief Justice Roberts, has indefinitely blocked the court order requiring the return of Kilmore Abrego Garcia. This ruling came out during the course of this hearing. So we now have the deportation of someone in violation of court order, and a further court ordering his return has now been countermanded by the Chief Justice of the Supreme Court. Senator Whitehouse, you are recognized.
If you read the appellate court decision regarding the stay, one of the things I think you'll note is the power of the language that was used by those judges. So I'm disappointed, I guess, yet again in Chief Justice Roberts' decision. I think we often read decisions which say the decision was misguided, the decision was erroneous, the decision was clearly erroneous, the decision was wrong, the decision stood on inadequate facts. In this case, the appellate court said the decision was unconscionable. You don't see that very much. So my questions will be to you, Mr. Croswell. I think you're the most experienced criminal prosecutor in the panel. And one of the things that we've seen has been the Trump MAGA crowd parroting the notion that there was weaponization of the Department of Justice against Mr. Trump, which is obviously a narrative that you would like to deploy if your leader is in fact a criminal, was convicted in certain places, was indicted in others, and had the prosecutive team say, hey, we had a good case here when it was closed down. So faced with all that evidence, obviously the thing you want to say is weaponization, fake news, all the usual denials. So I'm going to take a minute and compare what happened in a recent case, the one that was referred to about the unlawful effort to try to seize climate funds and because the veto period had passed by about 2 years, to cook up analysis that would have allowed them to seize the funds, had to cook up a crime that would give them the ability to say, well, while we're investigating this crime, we need to seize the funds. So that's the backdrop. And in the course of that, the first thing that happened is that the political appointee was told by his career staff that there was no evidence of any crime and they couldn't proceed. Do you recall any time in any of the Trump federal cases where a political appointee was told by the career staff that they had no case?
Senator, I've been doing the job for 10 years, and I can tell you that I have never, ever seen anyone, myself or anyone else, be directed to prosecute or drop a case based on politics.
Yeah.
It just does not
And in
figure
this case, the woman who was at the head of the office who told the political appointee that he had no case was forced to resign as her penalty for not going forward. Nothing like that ever happened in any of the Trump investigations that I can recall. Do you have any recollection of any career folks being fired for refusing to go forward with a case that had no merit?
Senator, my supervisors have always expected me to do the right thing. I think something that people need to understand about prosecutors is we're unique in the sense that our job is not to win our case, it's to do justice. And so every supervisor I've ever had would demand nothing less than me to do the right thing for justice. And if that means dismissing a case, that's what you would do.
Let me just go forward a little bit more, because after that, what happened is that the political appointee went forward with a pleading that no career attorney would sign. The only signature on it was the political appointee. Did you recall that ever happening in any of the Trump cases?
In my personal experience, I've never had a situation where I was asked to do something that, except for the Eric Adams case, that was the first time I was asked to sign something that
Unusual to go forward with a pleading where no career attorney will sign for the Department of Justice, correct? Only with a political
That's
appointee
unusual.
signature.
Yes, Senator.
Yes, it is. And then in the Trump cases, I don't recall anyone ever getting shot down, any of the prosecutive team, when they went for an order. And in this case, when the political appointee went for the order and went to the magistrate judge, he got shut down. When I was a U.S. attorney, if we got shot down for an order by one of our district judges, that would have been like, stop, figure out what went wrong. This is a never event. Let's figure this out so it doesn't happen. Do you recall that any of the Trump orders were ever shot down by a judge, or every time that prosecution team went to a court for an order, they were successful?
Senator, not sure about which order. I would say that it would be if I went to a court and was shot down for probable cause, that's happened, but you try to avoid that.
Yeah, you try very hard to avoid it. And after that's happened, do you ever go to another district to try to shop the same case where the judge had found that there was no basis to proceed?
It's never come up in my career, Senator. If I did, I would certainly tell the next judge that the last one found no probable cause, and that probably would not bode well.
And then I don't believe in the Trump cases any prosecutor ever made public statements outside of the pleadings about the culpability or wrong of the subject of the investigation. And yet in this case, both the political appointee and the agency chief who was engaged made public derogatory comments, false allegations, it seems, of fraud, defamatory per se. What are the concerns of the Department of Justice when political appointees make statements about the potential guilt or culpability of an uncharged person?
Senators, you're aware we conduct grand jury investigations in secret for a reason, because if we can't substantiate the case against someone, we close it without the public ever knowing, and that's to protect the American people.
And in this matter, the last thing that happened was that the agency had been going forward with its own case under the president's executive order, shifted to the fraud argument to try to improve its argument before the federal judge, not a magistrate judge, the U.S. District Court judge. And the U.S. District Court judge said, guys, there's no evidence here. You've shown me no evidence to support this claim that there's fraud or misconduct here. And yet they continue. And I can pretty well bet that in none of the so-called weaponized Trump cases was there a moment when a federal judge said, there is no evidence here, and yet the department continued it. So I guess the conclusion I draw from this is that there is fake weaponization, which is what you say when you're following somebody who has serious criminal liability, has been indicted, has been convicted, and you want to make all that go away with a narrative about, oh, that's just weaponization. And then you put your people in power, and what happens? The actual weaponization begins. And this counts, by my count, 7 red flags, any one of it which would have called a check to a case in the normal Department of Justice. So thank you, Adam. Thank you, Jamie.
Thank you, Senator Whitehouse. Recognizing Congressman Hank Johnson of the 4th District of Georgia and the ranking member of our subcommittee on courts, IP, and artificial intelligence.
Thank you, Mr. Ranking Member and Mr. Ranking Member for holding this hearing. You know, after losing the 2020 election, the lame duck President Donald Trump embarked upon an illicit and multi-pronged scheme to remain in office beyond his term. This plan culminated in the January 6, 2021 insurrection, which failed. But Donald Trump wasn't finished. Over the next 4 years, he hatched a plan to create the conditions where, if he won the presidency again, he would never have to leave office. And during that planning process, Trump was given an assist when the Supreme Court of the United States, which he magnified with 3 appointees, ran the clock out on efforts to prosecute him while giving him immunity from prosecution for official acts while in office. Once back in the White House and with immunity so that he was above the law, Trump's first order of business was to destroy the rule of law so that he could then systematically dismantle our democracy. And there would be no checks on his illegal behavior. In less than 100 days, he has turned the Department of Justice into the Department of Injustice. He effected this transformation by installing sycophantic loyalists and purging career employees whose only offense was adherence to the rule of law. Good people like our witnesses here. But even purging career employees is not enough for a tyrant. A tyrannical leader like Trump must also intimidate people to ensure their silence. And that's why Trump's DOJ directed armed U.S. Marshals to deliver a letter to Ms. Oyer at her home about testifying to Congress. And it's why the administration is now claiming that she is muzzled by executive privilege, which is a baseless claim. And going after government lawyers is not enough for this aspiring dictator. Trump is also attacking lawyers in the private sector in an attempt to decimate our system of adversarial justice, which is crucial to a functioning legal system. Any law firms that employed lawyers who previously investigated Trump, challenged his administration, or worked on causes he didn't like were slapped with executive orders. And these executive orders threatened to strip law firms of security clearances, terminate government contracts with the firm, or deprive them of business in any way that they can, even preventing their employees from entering government buildings. The idea is to scare lawyers enough so that no one brings cases against Trump or his administration's illegal actions. And even though Trump thinks he has the Supreme Court in his pocket, he cannot risk cases working their way through the legal system and finding out that even for the justices he appointed, it might be a bridge too far in destroying our democracy. So far, Trump has issued 5 executive orders targeting top powerful and wealthy law firms to send a message to the less powerful and wealthy that if you challenge his illegal actions, they'll be held to play. Several of his targeted law firms have folded like cheap lawn chairs, while others have stood and fought back. Trump wants to scare the legal profession into silence, and we're honored today to have these brave and patriotic lawyers with us who refuse to be silenced. Mr. Crosswell, you know, you found yourself at a crossroads after Donald Trump returned to office and Acting Deputy Attorney General Bove ordered you and your colleagues at the Public Integrity Section to sign a motion to dismiss the indictment against New York City Mayor Adams. Is it true that Mr. Bove told you and your colleagues that whoever complied would be rewarded with a position of leadership within the department, and that whoever pushed back would face professional consequences?
If I could interrupt for 1 second, the witness can answer the question. We're being reminded that we have just 5 minutes each. I think a lot of us on the House side were under the impression that people spoke for 15 minutes here, but it is a 5-minute rule we're going to comply with. Yeah.
Well, I've only gone for 5 minutes and 13 seconds. But if you would answer that question, I'll gladly yield back my time.
Congressman, my best recollection of the conversation that what was said to us was in my resignation letter, and I think it was very, very much implied, if not stated, that there'd be promotional opportunities for anyone that would sign the motion, and I also think it's very fair to say there was an implicit threat for those that won, and that was done through reference to what took place in the Southern District of New York. That's my best recollection.
Thank you.
Thank you.
Senator Klobuchar.
Yes, thank you, Senator Schiff. And I just want to correct the record, Representative Raskin. We don't speak for 15 minutes. We speak for 25 hours here in the United States Senate. So thank you both for holding this hearing. And thank you also for shining light on the simple idea that the president is not king. We are not a kingdom. And it is many of our colleagues, sadly, on the Republican side of the aisle are acting like subjects to the king instead of being independently elected officials, to the point where we're holding this shadow hearing because they won't hold such a hearing. So I'll start with you, Mr. Crosswell. And I, as a former prosecutor, I was so in awe of what you and others did after you were forced to drop bribery, or asked to drop bribery charges against Mayor Adams, and wouldn't do it. The words of the lead prosecutor on the case, Hagan Skoten, forever I will remember. He said, "I expect you will eventually find someone who is enough of a fool or enough of a coward to file your motion, but it was never going to be me." And I'm sure you felt the same way. Could you talk about why you made this decision?
Thank you, Senator. Senator, as I think I mentioned earlier, I would probably still be at public integrity. As deeply concerning as what happened with Eric Adams was, for me, the straw that broke the camel's back was what happened to my colleagues. These were individuals I cared about, and they had to resign because they weren't going to sign a motion that should not have been signed. And for me, and I think also just the fact that then we were ordered to do the same thing, for me, it almost felt like an abuse of power against me, myself. And so I didn't have a job lined up or insurance lined up, but I'd rather be unemployed and not be insured than work for someone that would do something like that to my colleagues and to me.
Okay, thank you. Ms. Young, kind of coming off that, how does firing career prosecutors or trying to make them to do something that they consider illegal, how does that weaken public safety, send the wrong message to law enforcement in general? Of course, this includes people who just happened to work on the January 6th cases, who were just called in to play various roles in it. Might have been someone who'd been in the office for a year or someone who'd been there longer. Just talk generally about how it weakens the rule of law and law enforcement?
Sure. Prosecutors at the Justice Department are some of the best lawyers in the country. So when you fire them, you necessarily make American communities more vulnerable. When you fire national security lawyers, you make our nation's security less tight. These terminations are due to career employees doing their jobs, accepting cases that they were assigned. Not prosecuting these cases would be insubordination. It's antithetical to the nature of career service. And people are resigning preemptively. And it's also going to prevent really great lawyers from wanting to go to the Justice Department. And lots of really great lawyers have always wanted to go to the Justice Department. So the more of these terminations we see, the more intimidation we see, the less safe we're going to be, and the less strong and seasoned and a DOJ will be. And without a strong, robust DOJ, the rule of law will suffer.
Exactly. Quickly, Ms. Oyer, Justice Department's taken oath to the Constitution. Could you, in 30 seconds, the difference between representing the people of the U.S. and representing the President? As we know, the line has been completely crossed here, as you know from your own experience.
It's very concerning that the department is currently being run by people, all of whom represented the president personally. There are certain decision-making authorities of the department that have been delegated to people who personally represent the president, including oversight of matters of ethics and professional responsibility. That's evidenced in the letter that was sent to me, which was sent to me by someone who was one of President Trump's personal defense attorneys. This is a way of stripping away any of the safeguards against the tremendous powers of the Department of Justice. The administration is currently attacking the safeguards within the department, as well as the safeguards external to the department, like the defense bar, that play a vital role in pushing
Which Ms.
back.
Cohen is well aware of. Yes.
Yes. So it's sort of a multi-pronged attack on the rule of law, and that has real consequences for real people, including things like individuals being deported mistakenly or individuals being swept up in immigration raids who happen to actually be U.S. citizens. It's very, very concerning.
Thank you.
Recognize the gentlelady from Pennsylvania, Mary Gay Scanlon, who is the ranking member on the Constitution Subcommittee.
Thank you for convening us today, and thank you so much to our witnesses. I really am in awe of your courage and your dedication to the rule of law, which is what makes our country great. And we all really, really appreciate your willingness to stand up and be counted when it really counts. Over the past few weeks, the White House has unleashed an unprecedented attack upon lawyers and judges who serve our American justice system, with the White House attempting to suppress challenges to the lawless orders that it is issuing. They're threatening and intimidating some of the country's most accomplished lawyers, some of whom are with us here today. Congress under Republican leadership has thus far acquiesced to this lawless behavior. The courts and lawyers are acting as the primary defense against executive action, and doing so successfully in the vast majority of almost 200 cases brought so far. I want to focus on the orders and sanctions issued against private law firms, because that's the world I came out of. These law firms have been selected because of their relationship to attorneys who represented the president's political opponents, opposed his administration's actions, or aided efforts to hold him accountable. These firms and lawyers targeted by the administration have been the standard bearers for the highest ethical obligation of their profession to provide free legal services in the public interest, or pro bono publico. They've been willing and able to dedicate top legal talent to undertake the costly and time-consuming work of ensuring due process in difficult cases, reforming broken systems, and vindicating human and civil rights of those subject to our laws. This administration's attempt to sideline these efforts stands in stark contrast to prior administrations which understood that our justice system only works when everyone has access to representation. And I'm thinking about 1963 President Kennedy's call to action to the most prominent law firms in our country, asking them to marshal the resources of the private bar to protect Americans' civil rights. The Trump administration has chosen instead to undertake a grotesque attack on the fundamental right of access to justice. So while the action of targeting private law firms are designed to hurt those most at risk, those who can't afford a lawyer, and specifically those with the guts to stand up to this administration's blatant violations of the Constitution, due process, and civil and human rights. Now, we've seen the administration's campaign begin to achieve its purpose, intimidating lawyers who might represent those challenging its actions. Some law firms targeted by the White House have settled with the White House. Others that have regularly participated in this kind of class action and other work in the past are declining to do so. This administration is employing the tactics used by authoritarian regimes to crack down on those who defend the rule of law. Places like lawyers, universities, civil society, and the independent media. So now is the time when all lawyers, law firms, judges, law schools, bar associations, and elected officials of every and no party have to stand up and condemn this attack. Because democracy doesn't only die in darkness, it also dies with silence or acquiescence. So I am encouraged by the growing resistance to these actions. And Ms. Cohen, whether willingly or not, you have ended up being a face of that. I understand that you participated in leading a letter that over 1,800 junior lawyers at these prestigious law firms have joined. Can you tell us a little bit about that?
Absolutely. Thanks so much. As I stated in my opening testimony, it was not my first choice to resign. I adore my coworkers. I did really meaningful work, both billable and pro bono. And I also expected that firm leadership would do the right thing, not just at my own law firm, but across the industry. And so something that was frankly quite scary was that all of the conversations about what the executive orders were aimed at doing and were doing, everyone agreed across political stripes, across level of seniority, that the president was targeting private law firms in an attempt to scare lawyers broadly. But no one was willing to say anything. And so I worked with a group of a variety of other associates to put together a way that people could anonymously express their concerns about this. We modeled it off a statement that was put out by the American Bar Association, a nonpartisan association, prior to even the Perkins executive order coming out in the first place about these troubling rule of law attacks. And so that was just one of many steps that we took to not reach this point in the hopes that firms would come together and do the right thing.
I do think it's really important that lawyers and law firms stand together. I mean, after all, it is through having a rules-based order that many of these law firms have been able to be so successful, and the erosion here affects everybody. So thank you. I yield back.
Thank you. And now it gives me pleasure to introduce Ryan. You'll be happy to know another former Marine, but also someone, Ms. Young, who has been leading our inquiry into what the law firms are doing, is Senator Blumenthal.
Thank you, Mr. Chairman. There is no such thing as a former Marine, as we know. Semper Fidelis. And thank you, Mr. Chairman, for holding this hearing, and to both of you, Senator Schiff and Mr. Raskin. Thank you, Congressman Raskin, for joining me in seeking to shine light, and for your support, Senator Schiff, because America needs to be aware, needs to be afraid of what is happening here, and needs to know that there are people like you who took the risk and made the sacrifice that others far wealthier, more resourced, and more powerful were unwilling to take, members of our profession who declined to stand up and speak out. But here's the good news for America. There are lawyers willing to take on this fight against a bully. 504 signed an amicus brief. Others are representing the firms. Let's say their names: Covington and Burling, Perkins Coie, Jenner and Block, Wilmer Hale, who are trying to break this pattern, and it is a pattern. Donald Trump hammers, bullies, intimidates, and then offers to negotiate. He's doing it with law firms. He's done it with universities. He's doing it with countries and companies through tariffs. It is part of a slide toward tyranny. Tim Snyder, my friend, a professor at Yale, has said the first rule of tyranny from the 20th century, the first lesson is do not obey in advance. That is what Skadden Arps, Milbank, and Willkie Farr have done. They didn't even wait for the executive order. They obeyed in advance. And I just want to make really clear what is most offensive to me. They acceded, in effect, to allow Donald Trump to tell them who their clients would be and who they would hire. I've been United States Attorney in Connecticut. I was Attorney General for 20 years, but I've also been in private practice. And if there's one thing that matters to me as a trial lawyer, and I still consider myself proudly a trial lawyer, it is nobody tells me what to do. And when I represent a client, it is 100%. And when I take on a client against a big corporation and then some other big corporation or that corporation offers a great representation to me, I say, sorry, can't do it. I've got the little guy whom I represent, and I'll give up the bonuses and the wealth and the money and the billable hours because I believe in my profession. Donald Trump has boasted, and I'm quoting him, that he has built, quote, an unrivaled network of lawyers. These lawyers are in his pocket. And when they're in his pocket, they cannot represent that little guy. They cannot represent the individuals that Willkie Farr did, that got them blacklisted. Ruby Freeman and Shay Moss, who volunteered as poll workers in Georgia in 2020 to help their fellow citizens vote in the midst of the global pandemic. He is depriving resources of people who really need that representation. And I'll tell you what strikes me as most abhorrent and repugnant, as reported in the New York Times, and Mr. Karp stated it, there were other law firms, and I'm quoting now from the New York Times of March 14th, some of the biggest competitors were calling top lawyers at the beleaguered law firm, one of the nation's most prestigious, asking if they would jump ship along with their lucrative clients. The firms are named Sullivan and Cromwell and Kirkland and Ellis. And Congressman Raskin and I are writing those two firms, along with the others, and asking them what they did to try to lure away those clients and partners, to try to poach their business and their resources. Most abhorrent to me is the potential that they acted in that way. Ms. Cohn, do you know of any specifics about attempts to take away lawyers or clients from either your firm or others that you may have heard?
Senator Blumenthal, I read the same report, and I think it's particularly ironic given that I'm also reading reports that Kirkland and Ellis is now in talks to acquiesce to the Trump administration in advance. So any clients thinking about jumping ship to any other law firm should remember that until they stand together, there's no chance that their new representation will be left alone either. But I will just say, I was a third-year associate when I left, and I wish you had someone more senior here to talk to you about this. But unfortunately, you do not, because the only people in this industry who have been willing to speak on this issue and give up their salaries in order to do so are associates, and I was not close to client work. But thank you for
I apologize for going over my time. I'd ask that the Truth Social and the New York Times story that I quoted be entered in the record.
Without objection.
And the distinguished lady from Vermont, Ms. Ballant, is recognized for her questioning.
Thank you to the chairs. First of all, I really want to acknowledge at the top the courage that it took for each of you to come here today. It shows an incredible amount of fortitude. These are incredibly scary times, and it's not easy to stand up and speak out against authoritarians. It's not easy to stand up and speak against the president. So all you have to do is look at our Republican colleagues, both in the House and the Senate, who are remaining silent. So the fact that you're willing to be here, to show your face, to speak up for what's right, it matters. And I have to tell you that this is a critical moment right now, and you are doing the right thing, even though it's frightening, because you're giving all of us just a little bit of hope in these incredibly dark times. Hope that we're going to be able to turn the tide on this. Hope that more people will see you and stand up to the corruption and the cronyism. And just a little bit of hope that we'll remember that who we are as a people, that we're beholden to the rule of law. And as my colleagues have said, that we are not beholden to a king or a dictator. So know that you are doing the right thing, even though it feels terrifying. Authoritarians like Trump have nothing but contempt for the democratic process and for due process. They mock the principle of accountability because they have none. They portray themselves as victims of so-called lawfare so they can discredit an entire system. That's what this is about. This is about discrediting the system. So we can't believe in lawyers. We can't believe in institutions. And that's terrifying. That is convincing all of us that the rot goes so deeply that the foundation of our very democracy can't be trusted. Ms. Cohen, in your resignation letter, which I have to say was such a shining light, you talk about fear and powerlessness that motivated some of these law firms in the country to cave. And that's what they did. They caved. They are bootlicking. They are bending a knee. Make no mistake, that's what's going on here. How is it that some of the most prestigious and powerful law firms in this country feel that they have to act in this way?
I wish I had a good answer for you, but when I read things like Brad Karp saying that it was an existential crisis for a firm whose profit per equity partner was over $7 million last year, I don't know what to tell you. I apologize.
That's right. That's exactly right. It's not an existential crisis where they're going to lose some money. We're talking about the rule of law. It's disgusting. And the courage that you have to be here when so many of your senior colleagues say nothing and grovel to a would-be king speaks volumes about your integrity. We're in strange times. There were protests across the nation. This weekend, the Chief Justice of the Vermont State Supreme Court, who, trust me, does not usually comment on political matters, he said, quote, "No prior administration has taken such concerted action against the bar. An effort to erode an institutional pillar designed to check abuse of power." When the Chief Justice is finding his voice and speaking publicly, you would think that some law firms could do the same when it's just about the almighty dollar. I want to conclude by saying Trump and all of his enablers, whether they're in Congress or whether they're at these law firms, seem to think that they can outrun this, that somehow we're going to ride this out. We're not going to ride this out. It's not going away. It's only when good people stand up and say, no, I refuse to bow. And my hat is off to all of you. You are showing courage that so many people in this moment are not. And I'm going to be able to go home this weekend, the end of this week, and talk to my two kids. I got 2 high school students. And they're going to want to know that there are good people doing the right thing, and I'll be able to tell them about this. I yield back.
Senator Hirono from the great state of Hawaii.
Thank you very much. And I thank all of you for being here. And obviously there were a lot of people here who really care about adherence to the rule of law. And I'm glad that I was able to make it for this portion. So I thank Congressman Raskin and Senator Schiff. So these are not normal times. We have a president who doesn't think that the rule of law applies to him, aided and abetted by a Supreme Court in their immunity decision. So what we have is a president who will go after anybody, including countries, corporations, law firms, anybody who he thinks can stand up to him. Basically, he is setting things up so that he can extort from them what he wants. And it is more than sickening to know that the people who are supposed to be standing up for the rule of law, I would say the lawyers, judges in our country, and we see many of them just, I would use the word caving, and that is why caving to the demands of this very corrupt president. So, Rachel, Ms. Cohen, thank you very much for having the courage and for you to note that, it's too bad that none of the partners who are making millions of dollars at your firm would stand up to do the right thing. It's pretty pathetic. And for the 500 or so law firms that filed an amicus brief on behalf of Perkins Coie, I say aloha to them, because if we don't all stick together, we're all going to be divided and conquered. So thank you very much. And for each of you, some of you who I know worked for the DOJ, in fact, I think it's Ms. Young, you worked for the U.S. Attorney's Office, you work for the DOJ, you have a wonderful background. I remember when we had the hearing on Pam Bondi, because she has said at some point that we should go after the prosecutors, prosecute the prosecutors and investigate the investigators. During her confirmation hearing in the Senate, I asked one of the witnesses who came on the second day of her hearings, what would be an indication that she is in fact weaponizing the DOJ to exact retribution, et cetera. And this witness, who happened to be a law professor at Georgetown, my alma mater, and she said, you're going to see people resigning, and that's what's happening, or you're going to see people being fired, and that's what's happening. All is not well in the DOJ. I did want to ask a specific question of Ryan Coswell. When Deputy Attorney General Tom Blanchard came before the Judiciary Committee, I asked him about why he was allowing attrition at a different part of the criminal division, the child exploitation and obscenity section, which fights child sexual exploitation. And he responded by suggesting that only U.S. attorneys' offices really prosecute crime and downplaying the role of criminal division trial attorneys in the DOJ. As someone who worked in both the U.S. Attorney's Office and criminal division, can you explain why having criminal division attorneys in D.C. is important and what we will lose if we gut the criminal division?
Thank you, Senator. What the criminal division litigating sections like public integrity bring is a degree of expertise. Mm-hmm. So certainly there are assistant U.S. attorneys around the country that can handle prosecutions of public corruption. We have a deep bench of very talented lawyers. They're experts in this. They can go all over the nation. And you mentioned that I have been in AUSA in other districts. When I was a prosecutor in San Diego from 2017 to 2020, I was prosecuting many immigration cases. And the entire time you had a public integrity section back in Washington. Hypothetically, if I had a situation where potentially a federal agent was allowing smuggling to happen because that agent was corrupt, I could call that public integrity section and get their help in prosecuting that case. And so if you worry about corruption, if you worry about abuse of power, it's good to have 30 or so attorneys who are able to take those cases on, which also allows the U.S. Attorney's offices to focus on violent crime, immigration crimes, fraud, predation on children. That's the value of it.
So obviously, but the Justice Department is not particularly interested in preserving the expertise or keeping the expertise in all these areas within the DOJ, and they have their own agenda, which is what I would not call it the people's agenda. Again, for Ms. Young, thank you, for what you are doing. And in fact, when the AG Bondi and interim DC U.S. Attorney Ed Martin referred to DOJ attorneys as the president's lawyers. I think you were asked this question before, but do any of you, but especially for you, Ms. Young, do you consider the attorneys at the DOJ or U.S. Attorney's Office the president's attorneys? And if not, who are they attorneys for?
Sure. DOJ attorneys are absolutely not the president's attorneys. The president is free to hire as many attorneys as he wants. Attorneys at DOJ represent the United States and the American people, and that's it.
And to think that we now have a attorney general who says she is the president's attorney, and she's certainly acting in that way. So there you go. It's just entire takeover of, I would say, an institution, the Justice Department, that is supposed to be prosecuting criminals and doing the things that I know that all of you have been asked. I can't tell what the time is there. What is that?
The time is up.
Okay. Well, that explains it. But we have so many concerns, and again, I thank each of you for resigning, being fired, doing all the things that requires a lot of courage to do. But we just need to continue to fight back. Thank you,
Senator.
I recognize the distinguished gentleman from Illinois, Mr. Garcia of the Judiciary Committee.
Thank you, Ranking Member Raskin and Senator Schiff, for convening this most timely and important hearing to spotlight Donald Trump's assault on our democracy and legal system, and thanks all the witnesses for standing for justice and democracy as well in your respective positions. As an immigrant and an organizer who hails from Chicago, who's fought for civil rights and against machine politics for decades, I understand that the rule of law has always been a work in progress in our country. Even before Donald Trump entered the political arena, many immigrants and working class people have felt that the law was written and enforced to benefit the wealthy and well-connected at their expense too often. But in the history of this country, the president has ever weaponized the law to this extent. No president has done that before, for his personal benefit and in the service of outright authoritarianism. My colleagues have highlighted many important issues, and I want to focus on the administration's shameful and unlawful treatment of immigrants. There are too many abuses to name in 5 minutes. Trying to end birthright citizenship, which is written into the Constitution, attacking jurisdictions that have welcoming statuses, and which studies show lower crime rates and increased trust within those communities. Creating a draconian registration requirement, which goes into effect this week, by the way, on April 11th, detaining Mohammed Khalil and others solely because of their protected speech. And of course, lawlessly invoking the Alien Enemies Act on false pretenses to detain people and spend taxpayer dollars to send them to a notorious prison in El Salvador. One of those people is Kilmar Abrego Garcia, a Maryland resident, father, and a metal worker, whom the administration sent to El Salvador despite Judge Boasberg's ruling and despite a 2019 court order specifically prohibiting him from being removed to that country because of the risk of persecution. Last week, the administration admitted that its removal of Mr. Abrego Garcia was a mistake. At a hearing on Friday, a senior career DOJ official, Erez Raveni, expressed frustration that the Trump administration had taken these actions and produced no evidence that Mr. Abrego Garcia is gang affiliated or that his removal was justified. The judge then ruled that the treatment of Mr. Garcia was shocking and illegal and ordered his return to the U.S. But instead of following the law, Attorney General Bondi suspended Mr. Raveni, and after the Fourth Circuit refused to block the judge's order, the DOJ has now asked the Supreme Court to step in, and it will. A ruling has not been entered yet on the merits of the case. In a sea of authoritarian lawlessness, this case stands out. So I want to ask you, Ms. Young, in your experience and based on public reporting, do you think Mr. Raveni's actions warrant suspension?
Absolutely not. And I know Erez Raveni, he is one of the most zealous advocates in the entire department, but he would never violate his ethical duties, including candor to the court.
What does his suspension tell you about DOJ leadership and its credibility?
It tells me that it values loyalty over the law, and I question DOJ's credibility right now.
And do you believe that what DOJ has done to Mr. Abrego Garcia represents a miscarriage of justice?
I am not going to comment on a legal question like that.
I understand. Thank you for that. We're living through one of the most shameful moments in our country's history, and it's incumbent on every one of us to fight back against this lawlessness. Your presence here is an important signal to the rest of the country that we are doing that. Thank you again, Ranking Member Raskin and Senator Schiff, for convening this hearing. I yield back.
Thank you, Senator Welch from the great state of Vermont and a great champion of the rule of law.
Thank you. And it's wonderful to see my colleague from Vermont here, Representative Ballot. Thank you. But it's mostly wonderful to see you here. Yeah, I'm interested in talking to you about why you became attorneys in the culture of law as you saw it and what you experienced. I'll start with you, Mr. Crosswell. You know, it's so amazing, the code of kind of, you're a Marine and a lawyer. Duty, honor, loyalty. I mean, just talk about the culture and why a culture is important. Not just personal values of an individual, but an individual is part of a team who's part of a culture that is the responsibility, when you're in that, to reinforce the positive values. Just talk to me a little bit about that, and then how that was challenged with what you faced.
Thank you, Senator. You're right. My first job in public service was as a Marine officer, and you're taught to always take the hard right over the easy wrong. And as an officer, you teach the people that you lead the same thing. That also applies in any law firm office, any prosecutorial office. It's about culture, because when you work for the government, you have an enormous amount of power.
Right.
You have to be a check on yourself, so to speak. And so when I was in the Marine Corps, I defended Marines accused of crimes of courts-martial. And there were certain clients that I got acquitted at trial. They were found not guilty. That wasn't because the prosecutors failed at their job. That was because they did their job, because they provided me with the evidence where I could defend my client. That's how it's supposed to be done.
Right.
And we need that in every U.S. Attorney's office.
No, thank you. Ms. Oyer, you know, that's an incredible decision to resign, and it's resigning from a job you love and working with people that you respect and admire, and then obviously the personal and professional implications that you're going to have to deal with for some time. So obviously there was a commitment to a culture that you saw being breached, and I'm going to ask you just to elaborate a bit on that.
So I was actually fired. The decision was taken out of my hands.
Well, you knew what would happen.
Yes.
You were fired. Yeah, I'm
that
sorry.
My role in the department was becoming increasingly untenable every day. It was becoming more and more difficult every day to do the job in a way that was consistent with my values and my obligations as an attorney. And honestly, on some level, it was a relief to be fired, to take the decision out of my hands,
Right.
although it required me to leave behind a mission that I cared deeply about and a team of people who I care deeply about. And I take some heart in the fact that they are still there carrying on the good work.
And you literally had a couple of armed marshals en route to your home when your teenage child was home alone?
That's correct.
Yeah, you know, I'm going to go back to you, Mr. Crosswell. Do you treat subordinates that way? I mean, is that at all acceptable?
No, Senator.
All right. And Ms. Cohen, you were friends with our beloved Mr. Raskin's son, and we've heard a lot about him. And I can only imagine the kind of commitment to public service you had and found a way when you accepted an opportunity to work at a major and prestigious law firm. Tell me about how you saw being in Skadden Arps, a major Wall Street, really world law firm, is being also an opportunity for you to live your values as an attorney, your commitment to justice, and also have an opportunity to work for folks who otherwise wouldn't be represented.
Absolutely. In part, I'm realizing that it was just very good marketing, but I do think that while I was on the job, I had unlimited pro bono hours. It was perhaps the most important thing to me when selecting a law firm, because I wanted to get trained up on the private sector things. My past work was in public education, and I needed to understand how those things work. It drew me to finance. But I devoted anywhere from 20 to 33% of my hours to pro bono every year. And ultimately, that is why I resigned. I'd love to say it was an abstract rule of law, anything else, but I did a decent amount of immigration pro bono representation, and actions by this administration are making it very clear that that is soon going to be viewed, or already is viewed, as adverse to the administration, despite the fact that it is just to allow people to survive when they are fleeing harm and persecution and death. And I couldn't stay at a place that I knew was on the verge of not allowing me to take representations that the president viewed as adverse, knowing what he views as adverse to him.
Right. Well, thank you all very much. Thank you. Thank you.
Thank you, Senator. I want to thank all of our witnesses for testifying today. Everyone in this room grew up in a period since World War II where we were used to seeing a world that was ever increasing in its freedoms. We saw walls come down. We saw new nations born. We saw the ever greater ability to express ourselves, to practice our faith, to associate with whom we would. And we came to believe it was inexorable. We came to believe that it was like the laws of gravity. Or it was, as Martin Luther King said, the moral arc of the universe always bending towards justice. Until all of a sudden it wasn't bending towards justice. And we've come to realize, much to our shock, that there's nothing inevitable about this. There's nothing inevitable about democracy or democratization, that this experiment in this country, this great experiment, self-governance, now 2.5 centuries old, is not inevitable. It was improbable at its start. And we've witnessed something we never would have imagined in this country. We have witnessed with incredible rapidity the creation of a climate of fear by this administration. We see universities afraid to speak out, to defend their own students, to defend their own academic freedom. You see universities rushing to make deals with the administration. You see universities cowed into silence, not stepping up to defend other universities. You see members of the press excluded from public events because they don't use the administration's favored parlance. And you don't see other members of the press in solidarity with them. You see law firms rush to cut separate deals. You see lawyers purged from the Department of Justice. You see FBI agents purged from the Bureau. You see scientists purged from their agencies. A wholesale effort to weed out and drive out anyone of independent thinking, anyone who will stand up and defend the rule of law or science or the freedom of thought or expression, right down to ordinary citizens who are now afraid. If the government of the United States can pluck a man off the street and send him to a prison in El Salvador without any kind of due process or any process whatsoever, then no one is safe. And if the government's response to that is to discipline a lawyer who dares to speak the truth to a court, then no one is safe. And the answer to this climate of fear, there really is only one answer, and you're seeing it today, and that is courage. We must demonstrate courage in the face of this fear. In this very committee room, or one like it, Joseph McCarthy and his allies made the country afraid and caused people to inform on each other and betray each other, allowed people and to be driven out of the government and to be persecuted. And we wondered how that could be. We wondered how could so many people be complicit. Well, now we know. Now we know. Now we have witnessed it in our own time. But I will say this of the brave witnesses who have come and testified today. All of the rest of us have to ask ourselves, looking back at the McCarthy era, what would we have done? What would we have done if we were faced with the loss of our jobs, if we were faced with the loss of our livelihood, if we were faced with the loss of our position? What would we have done? Well, you don't have to ask that question. Your being here is all the answer anyone could demand, and we are deeply, deeply grateful to you. I yield to my colleague and friend, Jamie Raskin.
Thank you, Senator Schiff, and thank you for your leadership. It's been an honor to conduct this proceeding with you, with all these wonderful guests and everybody looking at the proceedings across America. And thank you to our great witnesses here. Ben Franklin once said, "Make yourself a sheep and the wolves will eat you." And you are four people who have not made yourselves into sheep. You've shown us how to stand tough and stand strong against tyranny and despotism. And you and all of my colleagues here are speaking today in the spirit of our Constitution. We have an anti-monarchical Constitution. We've got no kings here. We have the freedom of speech. We've got no queens here, no emperors here. And we have no slaves here, and we have no serfs here. Just people, citizens, all of us together, standing equally under the Equal Protection Clause. We have an anti-monarchical Constitution. It forbids titles of nobility. It was so important to the framers. Congress cannot award or recognize titles of nobility. We've got an anti-cruelty Constitution. The Eighth Amendment bans cruel and unusual punishment. We've got an anti-corruption Constitution. It guarantees due process to everyone. It guarantees equal protection under the laws, as well as freedom of speech and freedom of the press and free assembly, the right to petition government for redress of grievances, free exercise of religion, no establishment of religion. And so we say to the courts, as Ms. Cohen said, you're an important line of defense. I don't think that you're the last line of defense. I think the people will always be the last line of defense, but you're a significant line of defense for us right now. We have 68 court orders that have been rendered by federal district courts, preliminary injunctions and temporary restraining orders against all of the lawlessness that's taken place. And we hope that the U.S. Supreme Court, which we know Donald Trump bragged about having packed and stacked in order to overthrow Roe versus Wade and get the Dobbs decision. We know that the court may be in a different posture on some of these things, but we ask all of the justices to live their oaths of office to uphold the Constitution and the rule of law. I ask them, I ask everybody in Congress, I ask everybody in the country to go back and read the steel seizure case from 1952, where President Truman ordered the seizure of the steel mills in the middle of a war, in the middle of the Korean War. He said it was a national security crisis and we couldn't afford to have a strike and a standoff between the unions and the management. And so he just ordered that all of the steel mills be seized. And the Supreme Court came back with a remarkable decision saying the president gets his power only from either the explicit text of the Constitution or from Congress. And Congress had already rejected the idea that the president should have the power to seize the steel mills. And so the court said in a 6-3 decision, the Constitution doesn't grant you that power, and Congress forbade you that power. And Justice Jackson, in his famous concurrence, said, at that point, your power, Mr. President, is at its lowest ebb. But here's the remarkable thing about the decision, which is indeed the paradigm for interpreting executive power. As Justice Amy Coney Barrett said in her confirmation hearings over here in the Senate, the remarkable thing about the decision is that there were 9 Democrats, most of them New Deal liberal Democrats, on the Supreme Court at that moment. President Roosevelt had been in for 4 terms. Truman had come in. These people, they were friends. A lot of the justices had served in the Roosevelt administration or in the Truman administration. Some had been in the Department of Justice. And in fact, the 3 justices in dissent taunted them, saying, you said this was totally fine. You wanted this to be a power that the president would have. And now you're on the court and you're saying the president does have this power. But it was really their finest moment because they distinguished their roles as partisans when they were either in Congress or in the administration from their role as justices upholding the Constitution and the rule of law. And they said, despite the fact that this was their team, they could not allow the president to overstep his bounds in that way. And after the case was rendered, Justice Jackson was so nervous that President Truman would never speak to him again, that he had a dinner party with all the justices, and he invited President Truman to come over there. And there was a round of toasts, and Truman said to Justice Jackson, well, I don't know if I like your law that much, but this is a hell of a good bourbon you're serving us tonight. So we hope that the justices will live up to their titles. They're the only jurists in the federal system who get the title of justice. Everybody else is a judge, and we hope these justices will act with justice. And I want to just say finally about the law firms, because I've been working with Senator Blumenthal and with Ms. Scanlon on the question of the law firms. There is no safety in appeasement. There just is no safety in appeasement. These law firms have bargained away $40 million, tens of millions of dollars in pro bono assistance. Well, now, if Donald Trump gets to choose who your clients are going to be, right, and you're going to end up representing, I don't know, the National Rifle Association, the National Right to Life Committee, you name it, anti-environment, anti-LGBTQ, whatever it is. Now, not only are you going to have to put the resources of your firm into these causes on behalf of a president who just shook your firm down, but you're not going to be able to take any of the clients on the other side, because that's a conflict now. You are conflicted out of representing the pro-environment, the pro-choice groups, the unions, if you've taken the people on the other side. There is no safety in appeasing a tyrant. There's no safety in selling out. And these people are teaching us what the meaning of the rule of law really is. Ben Franklin said, we must all hang together where we will all hang separately. Let's hang together right now. Let's stand tall, America, for our Constitution, our rule of law, and our democracy. And I yield back to you, Senator Schiff.
I thank you, Ranking Member Raskin, and we are adjourned.